Kia ora koutou, no mai haere mai, morena, and thanks everybody for turning up to today's QuakeCoRE seminar, which is going to be on disciplinary theme 3 and what we're planning to do over the next few years. Now, so we'll have presentations from myself, John Hopkins, Dr. John Hopkins, 10A. I'm a professor of law here at the University of Canterbury. And we'll also, my co-lead in the project is Ilan Noy. He'll be speaking today as well. Professor Noy, who's at the Victoria University, Wellington. And Olga Filippova, also one of our team members. She'll be talking as well. So I've got some slides. I'll just share my screen if that's okay. Oh, excuse me a second. I've made a mistake. Just bear with me. There we share the screen. Sorry, I used to be a technician, but I'm not a technician now because I'm not very good at it. So I think, is that the right one? Have I shared the right one with you? Yep, cool. All right, so so as I said, so today we're just going to have a brief overview, a workshop, I guess, of what we're doing in disciplinary theme 3, which is economics, law and planning. Sorry, there's a missing comma in there. With myself and Ilan Noy, I've just mentioned as the co-conveners. The other members of the team are, Olga, who you'll hear from in a second, Jeroen van der Heijden, and Nigel Isaacs, Eberhard Fies, Natalie Baird, Anik Maslow, and Tony Collins. Those are the ones who are on our bid formally, but obviously we'll link with others as we go along. So the idea of this disciplinary theme is to be a home, really, I think, for these varied disciplines, social science disciplines, starting with law, as I've just mentioned, myself and Tony Collins, but also economics in the form of Ilan and his colleagues, governance and architecture in Jeroen and Nigel, and Olga, who works in the now, sorry, I've forgotten the name of your department, but she works in buildings and housing. She'll talk property department at the University of Auckland. So we've got 5 sub-projects which are quite disparate, that cover a lot of different fields, and we'll talk a little bit about these during our presentation today. The first one is for A is Olga's. I'm not going to talk about Olga's because I'm going to leave Olga to talk about that herself in a few minutes. The second project, that's on percentage MBS, perceptions, impact, and consequences, and we'll link, I think, nicely to QuakeCoRE 1 research that we undertook in QuakeCoRE 1. The second project is headed by Jeroen van der Heijden, and Nigel Isaacs. Though Jeroen is now working in the Netherlands, and so Nigel will be, I think, taking the lead on that. Maybe Ilan may have more information. That is a governance project looking at the issue of long-term durability of buildings. So the fact that buildings are built and one hit, you fix the building code, and then you keep it for a number of years. We don't assess the buildings as we go along, and this is the idea is to look at this from a seismic resilience perspective, and we'll link nicely, I think, to work that was done in QuakeCoRE 1, which Cameron Eade, who's recently finished his master's, looked at some overseas models which do have not so much seismic, but have building warrants of fitness of buildings, if I can use that term, several times during a building's lifetime. So the issue there, they're looking at that from a governance perspective, and looking at regulators, the construction industry, and building owners as to how you could construct a system which would address the issue of long-term resilience of buildings over a significant time frame rather than the current model. That'll fit nicely, I think, with what we'll talk about in a minute in the law project, and also, as I mentioned already, the work done in QuakeCoRE 1. Excuse me. The third project is Ilan's, and headed by Ilan and Eberhard Fies, and that's on economics. I know nothing of economics, so I'll pass that over to Ilan shortly. He'll tell us all about that and his experiments. And the last 2 in this 5 will be housed at UC, or at least hosted by UC, and looking at legal frameworks around, firstly, more holistic legal frameworks about disaster reduction, or seismic resilience, excuse me, and then more specifically around dispute resolution led by Tony Collins. So the rest of the time, I'm going to talk about the role of law in seismic resilience, and particularly those two projects. So for my time, what I thought I'd do is talk a little bit about the issue of law and or the role that law plays in earthquakes and disaster studies. And I think it's often misunderstood. When I present at various disaster events and earthquake studies events, there's often, I think, confusion as to why there's a lawyer in the room. And I think part of the problem comes from the general misconception about what law as an academic discipline is amongst lay people, amongst the general population. And I think it's important to get a grip on that if we're going to understand what role we can play in QuakeCoRE and the sort of things we'll do in the projects that we're going to undertake. Now, when I ask, I won't do the sort of games I play with my students, but when I start my law lectures as first year law students, I often ask them what they think of when I mention the word law, and they usually think of things like judges and courts, or maybe the police and legislation and so on. Now, that's a very formal definition of law. We call that a formalist definition of law, where the definition is, or the conception of law is based upon the formality of a set of rules. Now, that's the dominant paradigm amongst lay people, and I think even amongst the legal professions, particularly in Aotearoa, New Zealand, where we're quite a formalist legal education system in the past, and so that concept's been very strong. But that concept isn't the one that dominates legal academia. It's theoretically problematic, and it's not the one that we certainly use in our work. The first problem with that concept is it's not really a concept of law at all. It's actually a description of our Western legal system. It's of a particular model of law where we use judges and courts and formal rules in the form of statutes and so on. Now, that's not to say that's a bad description or bad legal system or bad system, but you can't take that concept and use it elsewhere, because of course, when you go to states where or societies where formal law is less prevalent, so for example, in our own neighborhood, Pacific Island states, where you'll see heavy use of so-called custom or local laws rather than the formal state law, the problem is that that formalist definition doesn't include those other informal laws, if I can use that phrase, within the definition of law, and it sees them as sort of less than the formal law. So it's quite a Eurocentric conception. It's actually a Eurocentric description. It's a description of a European Western system of law. So it excludes quite a lot of other stuff that exists in other societies. It also excludes, and the second problem, there's actually quite a few, that it excludes elements of law that we would actually usually include in our discussion of law. So for example, international law doesn't have what we call a rule of recognition, which is a rule at the top that defines where all the systems are and how it works as a system. It's actually a collection of customs. But we treat it as law, and we use the term law around it, yet it wouldn't fall within that conception. Other things like tikanga or custom that I've already mentioned, practices that we follow on a daily basis, often don't have basis in formal law. The classic question often asked of people is, what are the official languages of New Zealand? The official, quote, formal legal answer is sign language and te reo. It's not English. However, in practice, that's clearly not the case. Customarily, English is our official language. So there's a problem there about excluding elements of the law that we think are important. And the problem, and that links with the final point I want to make, is it's not actually how society works. That if you take that formal approach to law, you can find out something that's 100% accurate, but not % useful. So for example, when we, all of us, certainly in New Zealand, I love a bit of DIY, and we go and fix our electrical system. When something breaks in our house, we'll go and fix it, despite the fact that we have very strict laws around electrical safety, which ban the average DIY person for going to fiddling around with the electrics in their house. Yet large numbers of people do it. Some of them kill themselves, but it's not suggesting it's a good idea. The point is, though, that in practice, this custom is how it behaves, not the law itself. the formal law itself. So you risk, if you just study the formal law, you get a very inaccurate understanding of what's happening on the ground. And this leads to a conceptual point. Is the law what happens, or is it just this formality? Now, because of the problems, there's a tendency amongst academics, well, more than a tendency, academic legal studies today tend to take a much more sociological approach to law, so that we define law not as the form of a set of rules, but rather the types of things that we are required to make a society work. Now, I haven't got a lot of time, so, and I don't want to keep going on about this too much, but the easiest functional definition of law that we tend to use is, that I use, is this one, which is from Llewellyn and Hobel. It's quite old now, but it's quite easy to understand, I think. And this makes the point that for a society to work, it's a sociological definition, you need to do four things. Any society has to resolve disputes, resolve the trouble case, to use the formal phrase, channel expectations, so basically ensure how you're going to, what's expected of you in your society, that's the rules, provide direction, decide who's going to, decide what you're going to do in your group or in your society, and finally, allocate authority within your system. The point to make here, though, is that from this definition, for this conception of law, it's not about the formality of the dispute resolution mechanisms or the way the rules are made. It's just the fact that they're made. That's what matters. So they can be informal, they can be formal, they can be courts, they could be, so in terms of dispute resolution, it could be courts, it could be tribunals, it could be informal discussions, community discussions, it could be fighting. And now, as a Scottish person, I quite like that as a way of resolving disputes. Maybe not the best, but it doesn't really matter. As long as the method that you accept within your society, then that's law. So this is a much, much broader definition of law, and it's the one that we're going to be utilizing in our projects. And it's based upon, it's a much more sociological definition. Now, once we understand that, I think we then clearly grasp the importance of law within disasters. Because once you realize that law is not just the formal rules, it's this sociological method by which we work as a community. And given that everybody in this room, I think it's this virtual room, it's everybody here knows that there's no such thing as a natural disaster. That disasters, of course, are the consequences of hazards intersecting with vulnerability, or sometimes you could use exposure, depending on the theory that you're applying. The point being that disasters, of course, are social events. They're caused by the intersection of the hazard with social decisions. Once you understand that, of course, and once you realize that law is a social phenomenon, then law is at the heart, not only of the response of a disaster cycle, but of the disaster, but at all aspects of the disaster cycle. And in fact, well-constructed law can not only be part of the solution in stopping an emergency or hazard even becoming a disaster, but bad law or poorly constructed legal frameworks can even be the cause of a disaster. And that's, again, something that we need to realize, that poor planning law, poor planning frameworks or building regulations can lead to a seismic event, for example, becoming the disaster. If you hadn't built buildings in a particular way or put them in a particular place, then the seismic event would have been an event, a hazard, a problem, but not necessarily a disaster. So poor regulation can create perverse outcomes that cause the disaster. So I'm running out of time, so I'll skip on quickly. So it should be clear now that far from being peripheral to the study of earthquake resilience, which I think is often the case out of people's perception, law is at the heart of such an understanding, and its role exists throughout the disaster cycle. Now, the role in preparedness and response is perhaps the most understood, although still limited in its understanding. Disaster law is not a big field. In New Zealand, that I think is due to agencies being clearly responsible for those phases. So the National Emergency Management Agency, in the case of earthquakes, has a particular responsive role. So there is more understanding amongst the legal frameworks there. However, for the next 3 years, we're going to be focusing more on the mitigation and recovery aspects of the legal framework around earthquakes, partly because they're less well understood, both in New Zealand and globally, partly because they fit with the new National Resilience Strategy, which we support this idea of thinking about building legal frameworks much more broadly around disasters. And finally, because it fits well with other research outside QuakeCoRE and work done in QuakeCoRE 1. This is just to make the point that there is a tendency of laws to be poorly designed around disasters, which is widely recognized and has been seen in the COVID pandemic. I'll skip over that because I really must get onto the projects. So just to say that the projects are going to be under the house within our institute, the law emergencies and disasters that we have at UC. And there's two projects that I've already mentioned. The first is much broader. It takes a holistic, it's too broad, this, quite frankly, this project. This is project D. So it's going to focus on mitigation and prevention recovery. This will be quite a unique project globally. As far as we are aware, there haven't been a project looking at creating holistic approaches to disaster response. So the idea is to look across the legal framework and consider how they connect. How does our what sort of areas of the drivers towards resilience exist across the legal framework in New Zealand, and then how can we build legal frameworks that are both pushes towards more resilience, and then the longer term in the recovery aspects that will provide us the tools and the ability to recover without the creation of new law during event. It should be said that there's a tendency in New Zealand to undertake this, that we actually have a policy to create new law around events. This is something that we in our most people in the disaster law group, disaster law field are not in favor of, because the last thing you need in the midst of a disaster is new frameworks to deal with. I should say also that we're keen on focusing, ensuring these are human rights compliant. One of the key problems that we have at the moment is that when disaster laws are considered, they tend to exclude or other some of those very vulnerable populations that we should be considering. So for example, disabilities around building regulation, I'll just make this as a particular example, are often not considered or not effectively considered, despite the fact that disabled people are exactly the sort of vulnerable population that you want to be considering in seismic building safety. And finally, the last project that that's currently a part of this, the legal framework, the legal elements of DT3 is run by Tony Collins. That's looking at dispute resolution after disasters. Much narrower than our broader project. Disputes are extremely common post-event. We saw this in Christchurch. We see it everywhere post-event, unsurprisingly, partly due to a lack of consideration about post-event issues that will be part of the previous project. But partly just the issues that arise: insurance claims, employment matters, tax contracts, lots of things arise. The problem is that we don't have effective systems in place to address this, and that leads to real problems with economic and human recovery. So what Tony's going to be doing is trying to gain a better understanding of what worked and what didn't. There was a lot of innovative stuff that happened around the Christchurch earthquakes. Also looking at some overseas examples where we know that there have been some at least perceived better approaches to disasters, to post-disaster dispute resolution. And also thinking about ways of, and this links with the previous project, of creating rules and structures in advance that channel expectations and thus reduce the needs for those dispute mechanisms in the first place. So I've gone over my time, as is traditional. So I'll stop now and I'll hand over to Olga Kakitiano. Thank you for your time.
Kia ora, John. Just share my screen. Well, I guess John has talked about regulations, and perhaps some of them might be poorly designed around disasters. But if we look at our Earthquake-Prone Buildings Amendment Act, it has all the good intentions. We do need to address vulnerabilities of our building stock, and not just new buildings, but existing buildings as well. But this particular regulation does did create some unintended consequences. And I think one of them that which we discussed a lot during our annual meetings and regular monthly calls is the percent NBS. This is, I think, one critical bit of information that a lot of us tend to latch onto, and that unfortunately created a lot of misconceptions within the society of how we interpret this percent NBS and what does it really mean. I mean, percent NBS, of course, is linked to the building codes, which really what percent NBS would indicate is the life safety of a building, which our building codes are centered on life safety, whereas kind of anecdotal evidence suggests that in the society, the way we tend to perceive this NBS percentage as some sort of business continuity, not just life safety. And so the idea of this project is kind of look into the root causes of how this may have happened. And so the way I see it is really looking at, well, who is spreading this misinformation? You know, we have our Amendment Act, 36 pages, which essentially boil down to a single table, which has percentages and kind of different types of NBS percentages, what kind of risk it implies. And well, I guess when we're talking about the built environment, we're talking about the owners of the building, we talk about occupants, but mostly all of the transactions between the owners and the building occupants are conducted with the real estate agents. I mean, they are the one who would be the people who kind of communicate the information about the building. And typically when we deal with agents, we tend to put a lot of trust in what they say. I mean, when we're buying a house, most of the transactions are done with an agent. And the same goes for our commercial spaces where it's pretty much all agency-based work. And so the idea is then to, well, how do agents take this information and interpret that and kind of relay that to the public? And essentially, even though it's very technical information, then it gets translated into something that gets to put into kind of listings where it's takes new meanings, essentially. For example, nowhere in the Building Amendment Act or the code will you find good seismic rating. What does it really mean? So the idea, I guess, is to look at how this kind of, over time, how the use of NBS has evolved in the, I guess, in New Zealand since the Act has been implemented. So I'll be looking at 3 different markets in New Zealand: Auckland, Wellington, and Christchurch. And just kind of preliminary, what we're kind of looking at more recent listings in the market and making just a word cloud of what is the most common terms that are used within the listings. And you can see that in Wellington, NBS is right front and center in your face, whereas if you go to Auckland, it's, you know, it's not very commonly used term, but there are already some interesting patterns emerge where in Auckland, for example, NBS is usually mentioned if the building is 100% NBS. That's kind of point of difference from other buildings. But if a building is 30% or less than 33%, then it doesn't tend to be mentioned at all. Whereas in Wellington, NBS tends to be discussed in terms of any type of risk profile of buildings, but so there is definitely a lot more awareness and acceptance of NBS percentages in the Wellington market, and the language that is used to describe the NBS percentages is a lot more rich, I would say, in Wellington. But again, this is all kind of these definitions that agents have created, such as higher than average or superior safety, favorable. But so these are some of the examples that are kind of emerging from the listings, and now, I guess, after all of these conversations that we've had in our QuakeCoRE meetings, I guess some things are starting to become more clear is where some of these misconceptions might be originating. And so the idea is, I guess, how can we perhaps better educate and develop regulations where we can communicate information in a way that it's intended to be delivered to the public. So I'll stop here and let Ilan continue.
Thanks, thanks, Olga. Ilan, I'll hand over to you now.
Thank you, everyone, and thank you, John and Olga. John is telling you that everything revolves around law. We all know that money makes the world go around. So I tend to disagree with John's view, but that's okay. So our project is on insurance specifically, and trying to understand, specifically trying to understand insurance decisions. So we know that the standard sort of economic take on insurance is that people make rational choices. They look at the probabilities, they look at the probabilities of an event happening, the likelihood of damage, how much damage is likely to occur. They looked at expected probability, expected utility that they may get, and therefore they make their decision about insurance rationally. We all know that that doesn't work, and people don't make decisions like that. And there's plenty of reasons why we now know that that's not the case. We know that people have biases in terms of assessing probabilities. They have various ways of thinking about small event probabilities, like availability heuristics, meaning what happened in the recent past is what's likely to happen in the future. So we haven't had earthquakes for the last 5 years, so the risk of an earthquake is low, but we had an earthquake, so the risk is high. On the opposite is the gambler's fallacy. I had a bad streak of dice, so now I'm going to get it. And all of these things that we know are not rational, because when you throw a dice, it's always the same probabilities, but people do follow these sort of rules of thumb. There's various other issues around these choices that are very, very well documented. So what we're trying to understand, how all these deviations from rational choice affect people's decisions around insurance. There are basically 3 ways that we can do that. One is theoretical investigations. So given all these, we can formalize all these ways in which people deviate from rational choice, and then use theory to guide us to what people will choose. That's one way to do it. We're currently doing a project like that, looking at the choice between parametric insurance and indemnity insurance. I'm not going to go into that, but that's one potential way to tackle these questions. The second one is to analyze real-world data. To anyone who has talked to me in the past 7 years about that knows that insurance companies are not very forthcoming with their data. So it's very difficult to get real-world data. We do have an exception here, and that's the EQC. But what the EQC has is limited in some sense. So we've had plenty of projects in the past that have looked at that. But what we have is only the records of those claims and not the records of insurance contracts in general. So that's another problem with the kind of real world data that we have. There's also various problems with analyzing real world data. It's hard to tease out correlation with causation and so on. And the third way in which this is going to be the focus of our DT3 projects is running experiments. Now you can do 2 types of experiments. You can do lab experiments, which is what we're doing. It's basically putting people in basically a simulation of an insurance choice and watching how they make those choices when they're in a simulated environment of an insurance, say homeowners that are buying insurance. So lab experiments, and you can do also field experiments, and that is basically to go potentially for example, convince an insurance company to sell various types of insurance contracts and examine what kind of insurance contracts people prefer, what is the price they're willing to pay for it, and so forth. So those would be field experiments. To do field experiments, we need collaboration with an insurance company. That hasn't happened yet, but we're all optimistic, and maybe someday it will. So that's the third way. I'm just going to briefly talk about, show you is how a lab experiment works like. So for example, just at the end of QuakeCoRE 1, we did a lab experiment that looked at basically an insurance choice. You could choose, you had a fictional house, you could choose to insure it, you could choose not to insure it, you could choose to insure it for 1 year or for 2 years. At the 2-year contract was at a slightly higher rate because it gave you certainty about the level of the contract. And then once you decide, you made this decision to insure or not, there was basically a dice being thrown, and at some small probability, your house was damaged. And if you bought insurance, you got paid. And if you didn't get insurance, you didn't get paid. Ultimately, economists strongly believe that people react to incentives. So the participants in those experiments are actually being paid at the end of the experiment. Okay, and they are being paid according to the choices they made. So if you chose not to insure your house and you were unlucky enough to experience an event, then you would be paid actual dollars less at the end of the experiment than you would if you chose to insure it. And the damage occurred. Okay, so that's basically what we are doing. A different sort of graph to show that again is you allocate a house worth 500,000, and then people have some cash so that they can pay for the insurance, and then they choose whether to insure or not. They pay some of the cash to insure. The dice is being thrown, and we can repeat this over and over and over. We can also observe whether people change their choices over time, and there are various things we can, once you start sort of moving the parameters of those insurance experiments, you can see how people make choices. Okay, so just from this example of an experiment that we ran it about 400 people or something like that. Almost 50% chose long-term insurance. This is interesting because long-term insurance is not available. So it's not a kind of contract that is available nowadays. So if you buy your home insurance, you're only buying for 1 year. So when we give people the choice, the opportunity to buy long-term insurance, even though they're paying more for it, 50% chose it. So that's a surprise. That seems to me to suggest that maybe there is a potential for another type of product that has various advantages associated with it. I'm not going to talk about what they are, but happy to talk more about that later. The other thing we noticed is we built in a mechanism in which the house prices go up. So we gave an opportunity to people to reassess every year, to reassess the value of their house, to see if they need to increase the value of their sum insured. Most people chose not to reassess, which is a problem if that's indeed the case in the real world, because that means that over time you're developing this underinsurance. Okay. And the other thing we noticed is that once people chose to do something, they remain stuck with it. So whatever choice they made, they stuck with it. So there's a very strong status quo bias. And the other surprise that has been documented before, but we still thought it would be interesting, is that even if you subsidize insurance by a lot, you don't really affect that much the choice of people. So even if you sell in a very subsidized insurance, you don't get more people choosing to insure than if the insurance is unsubsidized. This is what economists call the price elasticity of demand. So how demand changes because of price changes with insurance, and we know that also a bit from evidence in the real world. People don't really respond to prices. So if we are worried about underinsurance, for example, in the commercial sector, we are worried about underinsurance in the commercial sector, subsidizing that is not really going to change it. that much. Okay, so those are the kind of approaches and sort of policy relevant research that we can do. And I'm going to end there.
Thanks, Ilan. That was awesome. Thanks, Ilan and Olga. Fascinating stuff. I don't think money makes. I don't think it's just law. There's a bit of money.
Yeah,
bit of money. I accept that.
I think ABBA sang that it's a rich man's world, right?
It is. Although I always used it. I used it. So we've got a few minutes for a question, I should say. So if people want to chip in on a serious point, though, I was quite interested. I think it's quite good that our little theme provides these different approaches, and which I think hopefully we're like a home in QuakeCoRE for these different approaches, so that a little bit different from the engineering focus we see elsewhere. Nigel, I think you've got your hand up, so I'll go to you.
I just wanted to add something to what Olga had said, and if I can get away with it, I will try sharing my screen and show you the results of a piece of research that I would behave yourself. Right, you should see a slide that says commercial buildings, the challenge. This was a piece of research that I was involved in a few years ago, looking at energy use in buildings, which has or energy efficiency has a slight similarity, because the New Zealand Building Code Clause H1 is a mandatory requirement for new buildings. So just like the NBS, it's a requirement that's in there. But what was very interesting in the social science research we did, and we surveyed several hundred building owners and occupiers and managers, was what was called the virtuous circle, where the occupiers said, we'd love to have environmentally efficient buildings, but there aren't any. The builders said, we can build them, but the developers don't want them. The developers said, we'd build them, but the investors won't pay for them. And the investors said, we'd fund them, but there's no demand for it. And the occupiers said, we'd love to have them, but there aren't any, and so on around the circle. And I see a lot of similarities to the discussion from Olga on the NBS, where you have this sort of very strange market driven and manipulated by the legal requirements and by people's, at the risk of shooting myself in the foot, John, the non-legal interpretation of those requirements. I'd be happy to talk to you outside the meeting about that if it's of interest.
Yeah, and I've seen some of the reports that you have produced based on that project, because I have a student who is doing something on Green Star ratings for commercial buildings. So we did find that quite useful as well.
Right.
Thanks, Nigel. I'll leave you. You guys can discuss that offline.
Yeah. Ilan, I had a question about reassessing house value, but you mean the physical asset, the house, not the land and the improvement. So just the improvement, reassessing the value of that? Yes.
Yeah, that's the way we built the experiment. So the experiment didn't have insurance for land. It had insurance for a house. And you can think of it as the increase in the cost of construction.
But then isn't it offset by depreciation of your house? Because it wouldn't really be increasing much in value.
Well, so that depends on what you are insuring. Are you insuring the value that you have sunk into the house, or are you insuring so that you have a new house when and if it gets damaged? Our assumption here in this specific experiment, we didn't really go into the nuances of exactly what you're insuring and why you're insuring and so on. But the idea was the value of the asset that you are insuring is increasing over time. If you adjust your insurance cap, you would get more if the house is damaged. There was a 50% damage to the house if there was an event, an earthquake. And if you didn't adjust it, then you only get, you have more destroyed than you actually get repaid by the insurer. So, let's say the house value went up by 10%, and then 50% is so 50% of 110% is being damaged. So you get, but you are only compensated for the 50% of the older value. So you end up losing some money because of this, right? It's a very simple experiment because you need, and even this experiment is a bit too difficult. So you're always trying to, in experiments, you're always trying to construct a very simple choice architecture so that people are really clear about what they're making choices about. So we can't go into these kind of nuances. These kind of nuances we can get into if we run a field experiment with actual insurance company and actual contracts. But for that, the two major barriers are ethics committees in the universities and the insurance companies agreeing to actually sell different insurance contracts to different individuals. Both of these potentially are insurmountable.
But you also mentioned that households may prefer longer-term insurance contracts, but would not create a disincentive in terms of actually making your buildings more resilient. You just putting all this risk onto insurers.
Well, there are ways to deal with that. This kind of moral hazard problem, right? That once the risk is on the insurer, you don't have any motivation to maintain even the house. But the insurance company can build into their contracts mitigating clauses, right? In the same way they do for, I don't know, car insurance, and you need to drive safely, and you need to, I don't know, put an alarm in some cases if you have an expensive car and so forth. So there's ways to do that. Clearly, that's another complication that one needs to account for. We are specifically worried about the fact that people tend to buy insurance after an event, but then over time the rate of insurance goes down. So so that's one problem. The other problem is the insurance company can change, can withdraw, and that's a problem with sort of changing risks specifically associated with climate change and things like that. So if you can secure your long-term insurance, that changes the choices that you make. There's clearly trade-offs in everything. That's Econ 101, right?
Yeah.
Thanks, Ilan. Is there any more questions that we have on the call? I'll maybe ask you one to you, Ilan. Then following on from Olga's point, what about, given that I'm the regulation guy, so I have to ask the regulation question, what about regulating to saying, well, you can only access our market if you offer certain products or to the insurance companies? I mean, in effect, you find that with, there's compulsory insurance around car insurance in other parts of the world. What about requiring, I don't know, I mean, would that be a way of surmounting this?
We are unusual, right? Because we have a very, very lightly regulated insurance industry, right? We don't have an insurance regulator. In many cases, there is a very heavy regulation in the insurance sector. So in the US, for example, there's very heavy regulation. And insurance companies are only allowed to sell specific kinds of contracts, and those contracts have to include specific types of things. So if you're selling home insurance, you have to cover for these specific risks and so on. And there's all these instructions from the regulator on what you're allowed or not allowed to do. In some cases, you're not allowed to decline insurance. So you have to offer an insurance product to anyone who asks under certain conditions, and there are various things. We just don't have it's not that we are lightly regulated, we don't have a regulator for the insurance.
So there's plenty of examples overseas of those sort of models if you wanted to.
Yeah, so my favorite example is that Texas has an insurance regulator and we don't. But maybe Texas also tries to regulate the fertility of women. So
not all good.
Maybe they have a heavy regulation kind of attitude to life. I don't know. You can certainly regulate that if that's the question. Right now, we're not regulating the insurance sector at all.
Okay.
So
it might be something worth looking at from our side.
I'm
model.
doing another project with a consumer law expert, looking at mandating information disclosures. Because I think that's another sort of potential way we can improve If we mandate in the same way that, for example, in the US, they introduced, after the global financial crisis, they introduced these mandatory information disclosures on credit cards, which were 1 page, 14-point font, simple language, this is the interest rate, this is that. I think would be great if we could do the same for insurance, so that everybody's clear about what they're insured for and what they're not insured for. And that will prevent some of the, the legal cases that you've seen, for example, after Christchurch, and that were really harmful for the recovery.
Yeah, absolutely.
So there are various ways we need to regulate. I think we need to regulate the insurance sector, but yeah,
it's difficult. That's interesting. Really, really interesting.
John, I have a question to you. I guess this would have been more to Tony about disaster dispute resolution. But if you see the way the government responded to COVID, even though they didn't really do it in the first time, but this time the government has brought in some regulation in terms of the landlord-tenant relationship and how they should be resolving issues there, which I know landlords weren't very happy about that heavy-handed approach, top-down really. So I think in Christchurch, it was also more resolved by, it evolved over time, where the contract started to include these clauses where you can't access your premises, where it wasn't really before. So
yeah,
Tony
Tony's actually the expert on that. That's what she did her PhD on. So she's very much the person to talk to. The thing I would say though, so I've done dispute resolution in my past lives, but not on this. But the thing that always angers me a bit is that the poor person, I tend to favor, it's not there's usually a power imbalance. It's usually the ones that Tony were looking at, the tenants were in a poorer position, the smaller tenants against larger landlords. And the problem is that the system, you're right, it did over time eventually resolve itself. But during that time, the losses for those individual tenants was terrible. And the impact on those individual tenants was awful. And so a legal system that sort of fixes itself as it goes along leaves carnage in its wake. So what you need to be doing is have something in place at the start so that you can resolve these things without the disputes. Or in many cases, so again, Tony is really the person to talk to, but she mentions that many tenants actually had they could have got out of their contracts, because they couldn't access their buildings. That's what we're talking about. But there's nothing wrong with the building. That's the problem. But they were too fearful of going to court and all the risk and the cost, so they ended up paying two rents and all these terrible stories, which a better system in advance would avoid. A very reactive system, and we've done it again with COVID actually. Although we did learn a bit, and she's the one who'll explain. There are improvements in the contracts now to deal with some of these issues about inability to access a building, which was the issue that around Christchurch. But Tony is definitely the person to talk to about this. And then she'll probably say I got it wrong. Sorry, Ilan, did you want to say something?
Yeah, I think we need to close because we actually, the thing was supposed to finish 10 minutes ago.
Yeah, exactly. I agree. So I hope everybody enjoyed today's presentation. Now, I was told to remind everybody that the next one is on the 26th of November. I'm sorry, I don't know the subject, but I'm sure Ruth or Rosemary will let us know near the time. Okay, ka kite anō, thank you for your time, and see you next time. Bye-bye.
Matewa.